If a corporate subsidiary deliberately positions itself to avoid liability for using a dangerous substance, does that action justify piercing the corporate parent's corporate veil? The Third Circuit considered that question in Craig versus Lake Asbestos of Quebec, Limited. Owens Corning used asbestos in its products. Several suppliers provided asbestos to Owens Corning, including Lake Asbestos of Quebec and North American Asbestos Corporation. North American was a wholly owned subsidiary of Cape Industries, a British corporation headquartered in England. And Charter Consolidated, a British investment company also headquartered in England, owned a majority of Cape's shares. Charter named 3 directors to Cape's board of between 10 and 14 members. Most of Cape's board were Cape employees, and 2 or 3 directors were outside directors associated with neither Cape nor Charter. Cape's managing director sat on Charter's board. North American and Cape lost 2 asbestos lawsuits. Thereafter, Cape declined to defend any further asbestos liability cases, incurring millions of dollars in default judgments. Cape had no American assets and avoided paying on any of the U.S. judgments. North American dissolved in 1978. Clarence and Duveen Craig sued for Clarence's asbestos-related injuries in a Pennsylvania state court, naming Craig's former employer, Owens Corning, and asbestos suppliers, including Lake Asbestos and North American. Lake Asbestos pleaded Charter Consolidated, alleging that Charter was an alter ego entity of Cape Industries, and thus jointly liable for Craig's injuries. The case was removed to federal court, and the Craigs settled. Lake Asbestos settled conditionally, pursuing its contribution claim against Charter. The district court found that Charter was Cape's alter ego and awarded judgment against Charter for Cape's tort obligation. Charter appealed.